All right, let's go on the record on cause number DC 186688, Timothy C. Walsh versus Britain Building Maintenance. Council make appearances.
Carlos Galliani and Scott Legee for plaintiff.
It is Michael Lawrence for the defendant, Britain Building.
All right, I think there was some kind of motion you wanted to make first.
Yes, Your Honor. I filed a motion for summary judgment, but then when reviewing the response from the plaintiff, they had filed an affidavit from their expert and then also attached his report. However, his affidavit made no mention whatsoever of the report. It didn't incorporate it by reference. It didn't do anything. They just attached it. And therefore, that report is just inadmissible hearsay under Rule 802. And so that's why we moved to strike that. I'm not moving to strike the affidavit. I'm just moving to strike the report. And so we would ask the court to do that and not consider that evidence.
Response?
Your Honor, if he's not striking our affidavit, he's only talking about it, the report as being hearsay, we don't disagree with him.
Okay.
As long as the affidavit's still good, the report's hearsay anyways.
Right, the report is struck.
Okay. Thank you, Your Honor. And then now on to the main heart of this summary judgment is the plaintiff has made three allegations, three causes of action. One is premises liability, second is negligent undertaking, and the third is negligent, just straight on negligence itself. And the Honor mentioned that this case deals with mayonnaise, so I don't know how familiar you are with the actual nitty-gritty details of the facts, but I'll just do a brief summary, if that's all right.
I feel pretty comfortable with them. I know it happened during the workday on a stairwell, and there's an issue about whether or not your cleaning company was in charge of cleaning during the daytime as opposed to the nighttime, and they had I don't remember what they called them, but people that were there working, but they weren't cleaning people. So I'm pretty familiar.
Okay. Yes, thank you, Your Honor. I appreciate that. And so the stairwell issue is really important because this happened sorry, I'm getting something from the computer. The stairwell was the fire escape stairwell. This was not one of these internal stairwells. Like I worked in a law firm once, it was on 3 floors, and we would have an internal stairwell that connected all those floors. And it was very nice, granite and everything like that. It was not the fire escape concrete and metal stairwell, which is where this accident happened. And so the plaintiffs have referenced cleaning of the internal stairwells, but that's not where this accident happened. This accident happened on one of these external, on the outside portions of the building that, I'm not outside, but on the structure part of it, and it was strictly for a fire escape. Employees happened to use it to go up and down, to exercise, or to go to a restaurant, but it was not for just general use inside an office portion of the building. So the plaintiff has alleged premises liability. And with that, the court, I'm sure, is very familiar with those causes of action and what's required. But one of the items, number one items, is that Britain Building, who was responsible for cleaning, they knew or should have known of some condition on the premises, and they failed to exercise reasonable care to reduce or eliminate that risk. And the Texas Supreme Court has said the time element standard is very important as to how long was that dangerous condition present. And the plaintiff has absolutely no evidence of that. We last cleaned it on a Sunday night. This accident happened on a Thursday at 11 o'clock in the morning. There is no evidence that we were ever aware of this dangerous condition at any time before the plaintiff fell. He testified he has absolutely no evidence and doesn't know how long it was there. And so we think that on that basis alone, the plaintiff's premises cause of action needs to be dismissed because there is no evidence that that condition existed there long enough for us to have a reasonable opportunity to discover it. Courts have said that.
Didn't they argue that mayonnaise is something that stays around a long time and it could have been there for quite some time, unlike some other things like water that would evaporate?
That's pure speculation, Your Honor. I mean, they can't just speculate and say, yeah, mayonnaise is there for a long time. In fact, there are cases that talk about how long was the the marking in on the ground, and it looked like it was dirty and had been there for a long time. And the Texas Supreme Court and other appellate courts have said that's not enough. You can't just speculate just because mayonnaise may stay there a long time that it was there a long time. I mean, there's no evidence whatsoever. It's just pure speculation. And so we think that there's no evidence that we created the condition. There's no evidence that we actually knew about the condition. And there's no evidence as to how long it was there for us to have been able to discover it and then correct that condition. So we think their premises liability cause of action fails. The next one is on the negligence.
How much mayonnaise was it? Was it like a big pool of mayonnaise or just a little spot of mayonnaise, or how much mayonnaise was there?
Yeah, the speculation is that people would go down to the third floor and to the cafeteria and buy those like to-go lunches. And then we're coming up, and this happened on the 9th floor. And so our speculation is that it was one of those little packets, you know, that you squeeze out, you tear off the end and then squeeze out.
Yeah. So when someone like stepped on it?
Yes. That either the plaintiff may have stepped on it or somebody else stepped on it and he just stepped on the slippery, you know, substance. And so that's all we know. I mean, the incident report just talks about cleaning up a greasy substance or like a mayonnaise type substance. And so, yeah, it wasn't a big bucket of it or anything like that. And so
A bucket of mayonnaise.
Yeah. So anyway, so that's the premises one. The negligence one is that whether or not we owed a legal duty to the plaintiff to have been there at the time to clean it up. And that's where the contract comes into play. It's very important. The plaintiff is citing all these very general provisions at the beginning of the contract. However, there's a scope of work that is very specific that talks about when we do these things. And I don't know if you want me to share my screen, if I can do that. And
You're welcome to.
all right. It says I've been disabled. The host has disabled that feature.
I just enabled it.
Oh, you did? Okay. Oh, great. Thank you. All right. So here's the contract, the general contract. And with very general terms, and plaintiff highlights in their response some of these general terms, and I'll let them talk about those. But you have these very general terms. It talks about the normal working hours are 6 p.m. until 7 a.m. So that's the night shift. Daytime personnel work between the hours of 6 a.m. and 5 p.m. That's where those day porters came into play as to what their job duties were. Then we have the specific requirements. And as the court knows with the contracts, you interpret the contract as a whole. You don't just read one part out of context. Also, you may have general provisions, but the specific provisions are what control. And so it talks about the cleaning period. Services will be from 6 p.m. until 7:30 a.m. of the following day on weekdays. And so that's the cleaning time. That's when we're supposed to be cleaning. And then we go right here. This is Exhibit C, and this is the cleaning specifications. And these are the very specific ones. And this is where the plaintiff has focused on number 7, sweep internal stairwells and vacuums if cleaned. This did not happen in an internal stairwell. And so if you continue on with these very specific items, you get to item K, stairways and landings, and services performed weekly are to sweep the risers. And then monthly is to wet mop the risers, and quarterly is dusting the railings. And so we were not supposed to be there on a daily basis. We were not supposed to be there on a hourly basis. We were supposed to be there at the most on a weekly basis. And the time to do that is back over here at specific requirements. It says it's cleaned on the weekends or services from 6 o'clock to 7:30 a.m. of the following day, weekends and Sundays during the hours of 8 a.m. to 6 p.m. So there's been testimony that these fire escape stairwells were cleaned on Sundays during the day. This accident happened 4 days later. And so it was totally outside of our scope of work to even be in these fire escape stairwells. And that's why we have no duty under negligence or a negligent undertaking. And negligent undertaking is essentially the same thing, but with the added caveat that we, failed to perform the services and they increase the plaintiff's risk of harm. Well, our contract specifically states when we do this, we do it on a Sunday, and 4 days later, this plaintiff happened. The plaintiff has no evidence
So
whatsoever.
talk to me about the difference between negligence and negligence undertaking in this particular case.
Yeah, and this was a quote from the Knoll versus Plunkett case, Texas 2013 case, and it says basically the Supreme Court has said that the broad form submission for a typical negligence claim and a negligent undertaking claim are the same, except that a negligent undertaking claim requires a court to instruct the jury that a defendant is negligent only if the defendant undertook to perform services that it knew or should have known were necessary for the plaintiff's protection, the defendant failed to exercise reasonable care in performing those services, and either the plaintiff relied upon the defendant's performance or the defendant's performance increased the plaintiff's risk of harm. In all honesty, Your Honor, I'm having a hard time, distinguishing the difference really, but I think the key factor is that our failure to exercise a reasonable care in performing those services. Our contract said we clean those stairwells on Sundays once a week. We don't have a duty under the contract to go in there hourly or daily to look at those stairwells. We would only go in if somebody told us of a problem. And so whether it's negligence or negligent undertaking, we did not have a duty to be there. It was outside our scope of work. And so that's why we think the plaintiff has no evidence. And there's not a no evidence MSJ. I've attached evidence, but all of the evidence, the undisputed evidence is there's nobody knows how long it was there. And it was totally outside of our scope of work when we were supposed to be there. These day porters, their job duties was like to refill the bathroom and toilet paper and things like that. It was not to police and monitor the fire escape stairwells. And so therefore, we believe this case is perfect for summary judgment.
Response?
Okay. Can we address the issue, I guess, of our objection with one part of their evidence?
The
Sure.
declaration of Neil.
The corporate representative attaches, or the defendant attaches a declaration of their corporate representative. I guess we oppose it for 3 reasons. It's not clear. It's contradictory. The definitions that they use in the declaration for cleaning, for example, is not specific enough to, this. It's not specific to what they were actually doing, which is important in this case because there are definitions in the contract itself that are much more clear. So when they say, for example, that they were cleaning the stairwells, sure, were they sweeping them or were they doing what the contract actually requires, which is, our contention is daily sweeping, and we'll go to the contract. But as far as their declaration, it's too general, so it can't be controverted. It tries to say that that what's in the declaration is an exclusive list of what the job duties were for the day porters. Yet, I think if a declaration is contradictory to other sworn testimony, then that's a perfect reason to strike a declaration. And that's under the standard set forth in Tri-Code versus Montiel. So that it says an uncontroverted affidavit of an interested witness is proper only if the evidence is clear, positive, direct, and otherwise credible and free from contradictions and inconsistencies, and could have been readily controverted. So we're saying that their own deposition controverts what's in the declaration. So why have the declaration? And also that it's not really clear because they don't have enough definitions. There's not enough substance to the declaration to really make it effective at all. And it's duplicative in some ways and also contradictory in some ways to what's in the deposition.
Response?
Yes, Your Honor. One reason why I did the declaration is because this new Dallas County local rule says I can only have 25-page motion and a 25-page exhibits. And so to cut and paste from the deposition?
Just so you guys know, I don't really enforce that. So
Okay.
unless someone's just totally out of control. So there was a particular judge who really wanted that. And so I agreed that could be the rule, but I don't really enforce it. So don't worry about that too much. But
okay.
Anyway, go ahead.
Yeah. Well, and that was part of the rationale. Rather than cut and pasting from 20 different pages and then exceeding my limit, that's what I chose to do. But as far as that it's too general, if you go back and read it, Mr. Neal quotes from the contract, and he quotes, and actually I took a lot of his deposition testimony and quoted it verbatim in the declaration form. And so
I'm going to overrule the objection. Let's get to the substance.
Okay.
Thank you.
Okay, just to start with premises liability, Mr. Lawrence, attempted to argue that these stairs where this occurred was somehow external and not an internal stairway. And we can make this very simple for a jury, because if you look at an architectural plan of where this happened, this was in the center of the building, in the core where the elevators are. So this isn't what would be considered like an offset staircase that might be on the, attached to an exterior wall, or an external type of staircase that's not even enclosed, that would be a true fire escape. This was a stairwell that was used by employees, used by contractors, subcontractors, pretty much anybody with access to the building, and especially those that work there, which were hundreds of people, every day walking up and down these stairs. Apparently, they were highly used by employees there. So, we disagree with their characterization. There's nothing in the contract that defines these as a fire escape at all. And okay, so the contract has the
Mr. Leege, you're making me nervous the way you're kind of pacing back and forth back
Sorry,
there.
I'm just trying to, I'll sit.
okay, so Your Honor, I think if they had a point that they would be able to show you in the contract where it said fire escape or some kind of exclusion from the contract. But on the contrary, and I'll put up what the exclusions are in this contract, because this is a very encompassing contract that the building ownership and management delegated all duties that are, all duties having to do with cleaning to Britain Building Maintenance. So the purpose of this contract, from that standpoint, was to include everything except what they meant not to include. And the only parts of the building that were not included, and I think it would have said something about staircases here, are the engineering, mechanical rooms, and telephone rooms, which is part E under section 3. And again, there's nothing in here that talks about anything other than stairways, which is a very broad term for stairwells, staircases, stairs. Stairways is a very broad term for that. Our expert's affidavit has some clarification on that definition, but we disagree with them saying that this is not a stairway that is internal to the building.
Well, let me ask you this: what's in this particular case? What's the difference between negligence and negligence undertaking?
Well, Mr. Lawrence, he had a difficult time distinguishing. I think we pled that as a we're being somewhat legally creative here on what occurred. I think we can make the case that this is a negligence action, and the negligence.
What facts would there be to make this into a negligence? I can see negligence undertaking. I can see premises. I just don't see negligence.
Well, the undertaking, I guess, being the cleaning services themselves. That we were saying that the contract imputes a duty to the cleaning company, which is we will, we can get there, but negligent undertaking, let me see what the case.
Hold on. The judge asked a question about, he hasn't seen negligence. Is that right, Your Honor?
The Knoll versus Pluckett case.
Just show them the police. Negligent, and then they show the duty in the catch-all phrase. That's why there's, Your Honor, we're going to show you a couple of items in the contract. One is policing. The other is the catch-all phrase.
But that's all goes to negligent undertaking. That doesn't go to negligence, does it?
It does. You're going to see. Because first they have a duty to police, and then second, Your Honor, there's a catch-all phrase. Put it up. The catch-all phrase says, when in doubt. I got to get it. Oh, sorry. Where's the catch-all phrase? The second one in the contract.
There's a few of them, yeah.
You're the one that is there it is. Okay, so in this catch-all phrase, Your Honor, this is regarding negligence. It says specific. Is that it? No, that's not it. I'm so sorry. You know what?
Okay.
Are you talking about the beginning?
The one that has the catch-all, the one that.
Sweet, very sweet, clean.
No. Oh, the one that.
Contract. It's all on those 3 pages.
Sorry, Your Honor. It's not it. Remember, it says the duties. Here we go. Okay, now can you zoom that up a little bit? Your Honor, sorry about that. Specific requirements, second paragraph, G1, second sentence. In addition to the first sentence, which says all janitorial services to be performed shall include, but not necessarily be limited to those described below, it also has a catch-all phrase. Any other services necessary to meet the standards for similar office buildings will also be expected and demanded. And our expert has stated that it's other similar tie-rise buildings like this, that all common areas should be inspected at least once a day. Now that breached the standard of care and they were negligent. Now, unlike, and this is like, as you've done this a million times, it's a battle of the affidavits. Our exhibit, our evidence that presents a genuine issue of material fact is our affidavit from our expert, as well as the ambiguous contract that Mr. Lawrence is relying upon.
Okay, I get what you're saying, but
Here's what they're saying.
this everything you're showing me seems to go to the issue of negligent undertaking. I guess what facts would have to come out for there to be a negligence case in this? Because I guess I've always thought of negligence as something where you're actively doing something that causes injury. Like, is there any evidence that they actually dropped the mayonnaise? I mean, the classic example is a worker spraying, concrete and somebody falls on the concrete. That's what I think of as negligence. I don't see somebody leaving.
It's the act.
Cleaning up mayonnaise.
It's the act or omission. And in this case, the omission was their failure to inspect. Mr. Lawrence even stated that we don't know whether this mayonnaise was on a Sunday or a Thursday.
But doesn't the failure to inspect just come out because of the contract, and that would make it a negligent undertaking? They don't have a duty to clean the stairwell but for the contract, right?
Except for the fact that if other similar office buildings required that these stairwells to be inspected on a daily basis and cleaned, then they breached the duty to act as a reasonably prudent cleaning company.
Do you have any
in the same or similar position with the standards of what the other offices do and don't do?
Do you have any cases that have applied a negligence cause of action in a case like this?
Oh God, this is a case like this in general.
I'm really actually trying to help you, Mr. Leachy, because I think if you try to plead this as a negligence and this goes to trial as a negligence case, even with our more reasonable court of appeals now, that I think you could get reversed. I think it just makes more sense to do this as negligent undertaking and premises. But if you
and that's fine, Your Honor. This is I'm just giving you my answer. I'm not saying that I'm right.
Well,
I agree with you that this should be a premises and a negligent undertaking. But I have to argue zealously for all of our causes of action.
Well, you don't have to. You really don't have to.
Okay, Your Honor. Well, then how about we move along on negligence and let you take that under advisement. And we'll just work on the other parts. Because it seems like you've made up your mind, and I don't disagree with you.
Well, no, I want to know if there's some cases out there that I haven't seen that would apply negligence cause of action to a factual situation like this.
We don't have anything for you, Judge, not as we sit here today.
Mr. Lawrence?
I don't have any cases, Your Honor. Obviously, I don't think it applies.
Yeah, well, I don't think it does either, but so why don't I do this? I'll go ahead and grant it. It's obviously as to the negligence cause of action, I'll deny as it comes to negligence undertaking and premises. But obviously it's just an interlocutory order. So if you find cases in the future that say a negligence cause of action would apply in this type of situation, I'd be glad to look at them. But for now, let's go ahead and do it that way. So Mr. Gallinia?
I'm still here. Thank you.
Galliani?
Thanks, Judge.
If you could go ahead and prepare an order for me that details my rulings on the motions to strike or actually, Mr. Lawrence, you're billing by the hour, aren't you?
I
Yes,
can do
Your
it,
Honor.
Your Honor. We understand what you're asking.
I'll let Mr. Lawrence do it. So why don't you prepare
Yes,
me an
sir.
order on the motions to strike and the motion for summary judgment and run them by Mr. Leegee and Mr. Galliani. Okay?
Yes, Your Honor. Yes.
Good to see you guys. You be safe. Good luck. Did you say you have a mediation coming up or no?
On December 9th.
Who are you mediating with?
I think, is it Judge Pfeiffer?
No, Adam LaCrone.
Oh, Adam LaCrone, that's right. The owner of the building settled out and he mediated that case.
Okay.
So
Who are your favorite mediators these days?
I like,
Mike Bassett.
What'd you say? I
It's
couldn't
hard to
hear you.
get. Adam LaCrone is really good. Mark Gilbert's good. Mike Bassett's good. Mike Carnahan's good.
I like Karen Gammon a lot because Karen speaks Spanish, so that really helps with the Spanish speaking plaintiffs.
Uh-huh.
And then also I like Judge Pfeiffer too. You know, we have complex legal issues. You know, he's really good.
Yeah, I've heard a lot of good things about Pfeiffer too. I have you guys used Jordan or Lowy or
I've used them once each. They
Ginsburg?
did good. It was on small cases. I've used them once on each of those guys once. I
So what
like
about
I like Jim Jordan better than Lowy, but they both got them done. They were small ones.
Mr. Lawrence, what about you? Have you used them?
I haven't used Lowy in a while. It's been over a year. I haven't used Jordan. Jim Janot, I've used on some pretty high exposure cases.
Jim's good.
Yeah.
It's interesting. I'm out of the game for so long. I used to just send my mediations to people I knew for these personal injury cases, and I'm kind of out of the game. So, all right. Well, good. It's good to hear that. And I will go ahead and get me an order on that, Mr. Lawrence, and you guys be safe out there. Okay.
All right. Thank you.
Thank you, sir.
You too.
I think we have a motion for sanctions next. Is that right?
I believe so. Good afternoon, Your Honor.
Afternoon.
Unless there's another motion for sanctions, I believe it's the one defense counsel Catherine Reed filed in our case, Chastity Casey versus Denilson Silva.
Miss Reed, are you there?
I'm here. Can y'all hear me?
Yeah, but
I don't know why my screen's not working. It says it's on.
it's very strange. It looks like you're like
Oh, it's on the rear, I think. Let me see.
it looks like you're a screen door.
I think, surface.
I've never
cam-
seen anything quite like that.
It should be flipped. I'm not sure. Give me 1 second. I apologize.
It's okay.
Judge, you getting ready for trial tomorrow, huh?
Yeah, but jury trial. I missed my jury trials. We're hopefully going to have a remote jury trial tomorrow.
It's with David Maldonado, right, and Chad Archibald.
Yep. We had 4 cases to start. We're down to 1, so we'll see what happens. But I'm feeling like I see a way this might work, but there's a lot of technical issues that hopefully will not go wrong. So we'll see how it goes.
I gotcha. And then I know it looks like we're live on YouTube now. So is David's case tomorrow going to be live on YouTube as well?
It will be once we get the jury selection started.
Nice. We'll have to peek in then tomorrow.
Should be interesting. We'll see how it goes.
Yeah.
Miss Reed, you're taking a pretty aggressive stance here. So
Yes, Your
let's
Honor.
let's kind of talk about this. So what's going on with your client, Mr. Hancock? It sounds like he's had some issues, and I understand Miss Reed's frustration, but
Yeah, absolutely, Judge. And I get where Miss Reed's coming from as well. I think honestly, after talking to Miss Casey, the last time that I spoke to her was after the last one, obviously, that she missed. And I just don't really think that she really appreciated the ramifications of what was going on. Again, you have a detailed kind of timeline between defense counsel's motion for sanctions and my response to it.
is there a way you could get
some of-
your client on the Zoom call?
Yeah, absolutely. Well, that was the issue was the first time she was ready to go
I mean,
and she
this
just
Zoom
couldn't
call, could you get her on
link in.
this?
Oh, I could, yeah, let me see if
Or
she's
at least
available,
call
but
her and
obviously,
see if maybe you could call her on the phone
Yeah.
and have her on speaker or something. Because
yeah, absolutely.
I fully understand, Miss Reed, where you're coming from. I understand why you're frustrated. I do know that, Zoom, welcome to my world. I deal with this kind of stuff all the time where people don't know how to use Zoom.
Right.
We've had some really crazy things. And so, but I also don't think it's fair to you to continuously do this and then the client doesn't ever show up.
The second and third deposition, she said she was going to go to their office and she just never showed. So that was part of it. I didn't want to keep noticing it, keep incurring the cost.
I don't blame you.
Yeah.
I'm not fussing with you. I just want to, it's just such an extreme remedy that you're asking for. And so my thought is that we get her on the phone, see if we can't, explain to her how important this is. And then if she doesn't show up to the next one, then there would be like $1,000 in sanctions against her personally, to try to encourage you to, we can't just keep letting this go, but I do want her to understand how important this is.
Yeah. Thank you, Judge.
So what was going on with your computer? I've never seen that happen before.
We actually just moved offices and they put these tack boards against the wall.
Oh, okay. So you were just facing the wrong direction.
It was going the wrong way.
What firm are you with?
McDonald Sanders in Fort Worth.
Judge
So,
Hoffman, I have her on the line. Just give me 1 second. She's having the kids go inside, or she's going inside so she can hear.
Okay. And her name is Miss Casey, did you say?
Yes, Miss Chastity Casey. Miss Casey, are you there?
Yes, this is me. I'm here.
Can you hear that, Judge?
Yes, Miss Casey, can you hear me? This is Judge Hoffman.
Let me increase the volume, Judge, real quick and see if y'all can make sure y'all can hear each other. Okay, Miss Casey, can you hear the judge?
I can barely hear the judge.
Miss Casey, can you hear me okay?
Okay, now I can hear you. Yes, I can hear you a little better.
So Miss Casey, I don't know if your attorney has explained to you, but the defense attorney in this case wants me to dismiss your case and award attorney's fees against you because you didn't show up to these depositions. And I don't really want to do that. I want to give you a chance to fix this and make this right. But I just wanted to find out kind of what's going on. Do you still want to pursue this case? Are you going to show up the next time, or kind of what's going on?
Yes, sir, Judge. The first time that we had the deposition, when I got ready to download it, my phone was not compatible in order for me to download it. So the first time we had to miss that one. The second time, my nephew, he had a situation with the COVID that he was put out. So I had to go get him where he's staying with me currently. So I wasn't actually in the area with the Wi-Fi to be able to connect to my phone to do the Zoom at the time because I was out in Idabel, Oklahoma. And the third time, I clearly thought that the deposition was at 2:30. And when Mr. Hancock called me, he let me know that it was at 2 o'clock and not at 2:30. So I had 3 different times. So I got my timing mixed up with the third one. So I do apologize, on my part, I do.
So I kind of feel like I have two choices here, and I want to kind of talk to you about them. One is Miss Reed is very, very, and I understand her frustration because she spent time and money to try to get this. This is a very serious procedure that you're going through. And she spent time and money on that. She wants to dismiss your case and wants me to award attorney's fees against you. I think that's a little extreme at this point. And so the other option I thought of is to give you one more chance, but this would be your final chance. And if you don't show up next time, then they would award $1,000 in attorney's fees against you if you don't show up. Which do you think is the better way to do this?
I will definitely be there for the next deposition. I will put whatever I have to do aside with the working and everything. So I'll just put everything aside that I need to do. If y'all can give me the time in a timely manner, when I can tell them I can't be at work. So that would be awesome if you can do that, Judge.
Okay, well let's see what we can do, Mr. Hancock, Miss Reed. Let's figure out a time that will be available for all three of you so that we can get this thing set. I know Mr. Hancock, you and Miss Reed's schedules are pretty busy, but when do you want to set this? And I'll kind of let Miss Reed, because she's the one who's kind of been the put out person, kind of have the first choice.
Your Honor, I'm pretty open next week. If there's a day next week that works for Miss Casey and her attorney.
Mr.
Yes.
Hancock?
Yes, Your Honor. Ms.
But
Casey-
is Thanksgiving next week?
Yeah, Thanksgiving's next week.
Oh, okay. I guess I am busy next week. But I'm open that Monday, Tuesday, Wednesday, if one of those dates work for you.
I have four to go ahead, Miss Casey. What day, is there a day of the week that's better for you, Miss Casey?
Well, I was going to say either Monday or Tuesday would be perfect for me. Anytime in Monday or Tuesday would be a good time for me.
Mr. Hancock?
Get it out the way.
Judge, I got 4 depositions on Monday and 3 mediations on Tuesday. So I would suggest my Wednesday is wide open. I know that that's not really conducive to everybody else's schedule, or I'd suggest as of right now, the following Monday after Thanksgiving, that November 30th, my schedule's wide open. I'd be able to do any
Miss
date.
Reed, how about you for the 30th?
I'm available on the 30th. That would work for me.
Okay, Miss Casey, are you available on Monday, on the 30th, the week after Thanksgiving?
Yes, I am.
Okay, and that'll give you enough time to make sure with work that you're cleared and you're good to go?
Yes.
Okay, and then
What time did you say?
yeah,
Do you want to say mid-morning, like 10 o'clock?
I think 10 a.m. is a good time. 10 a.m. works for me. Does 10 a.m. on Monday, November 30th work for you, Miss Casey?
Yes, it does.
All right, Miss Casey, please don't make me look bad here. Miss Reed has been kind of chomping at the bit to try to get this thing done, and I'm trying to give you one last chance. So please don't make me look bad. I need you to show up, okay?
I promise you, Judge, I will be there. I will not make you look bad.
All right. Hey, I appreciate it. You be safe and have a great Thanksgiving, okay?
Y'all also.
All right. Thank you.
Thank you, Miss Casey. I'll call you soon, okay? Okay.
Okay. Bye-bye.
Your Honor, if I could just add, I'm okay with all of that, but we're still out $900 cash and expenses. For each non-appearance, it was $300, and I don't know if the court would consider that to be reimbursed.
Mr. Hancock?
I mean, I understand defense counsel's frustration, but I mean, it's not the first, it's not the last that we've had defendants not show up for depositions. I just.
Is it really $300 now for a non-appearance? That's back when, I guess it's going to show my age, but back when I used to do this, it was like $75. So I guess
It was, and I attached the invoices, Your Honor. And so that's a lot of the push I've gotten to pursue this is the expense we're out.
What do you think, Mr. Hancock?
Again, Your Honor, I understand Ms. Reed's frustration, and we don't like having to reschedule court reporters and things like that. So again, I understand her side, but at the same time, I just respectfully ask that that you deny it, just because, again, trying to get this case settled to begin with, any sort of fee or penalty kind of put on us is just going to make it harder to get the case settled.
Have y'all been to mediation yet?
That's another problem, Your Honor. We were set to mediate it on October 23rd, but because she didn't show up that whole week, we had to move it. And now it's not set till, I think, February, but trial's in December. So, although this case hasn't been pending very long, but we haven't really gotten into discovery yet.
Do you want me to reset the case now? Would that make you feel a little better?
I always like seeing your face, Judge, for the Zoom hearings, but yeah, as of right now, it doesn't look like we're going to be able to mediate it prior to our current setting, which is December 8th.
Ms. Reed, when would you like to do you want to reset it? Is that your preference, or do you want to try to go in December and try to do an earlier mediation, or what do you prefer?
I would be okay with the reset, Your Honor.
When would you like to reset it to?
I guess it all just depends on jury trials, but maybe mid 2021. The case isn't even a year old, so it hasn't been.
Yeah,
We
I'm
haven't
okay
done
with that. Do you want to shoot for like June?
Yes, Your Honor, that would work.
Mr. Hancock?
Yeah, June works for me. I imagine that will give us enough time to, we'll have Miss Casey's deposition done by the 30th, and then, hopefully have mediation in February if we can't get it resolved before then, and then hopefully COVID clears, and that way we're not getting, reset, but we'll just deal with June when it comes.
So we're going to reset you to June 21st, 2021. Ms. Reed, if you could prepare me an order for the sanctions, which will be if she fails to show up for the November 30th at 10 o'clock hearing or deposition, then the court will assess $1,000 in sanctions against her. And the court will take under advisement the issue of the other fees.
Yes, Your Honor.
All right. Anything else, guys?
For the one under consideration, should I go ahead and submit a proposed order on that one as well?
What do you mean?
If you're the one you're taking under advisement, Your Honor, I just want to make sure there's
Just included as part of the same order.
Okay. Yes.
This request for future sanction will be taken has been taken under advisement.
Okay.
In reality, I'll probably just, if she continues if she is reliable and and shows up like she says she's going to show up, then I probably won't award any sanctions. But if, like, say, for example, you go to mediation and she doesn't show up to that or whatever, then this is something you can kind of pull out then.
Yes, Your Honor.
Does that make sense?
Yes.
Mr. Hancock, anything else? Make sure you share this order with Mr. Hancock and then email my court coordinator and e-file it as well, the order.
Okay.
Yep. Yes, please. And then, Ms. Reed, I'm assuming you'll send out a new notice for the deposition, right?
Yes, I'll send that today.
Okay, perfect. I'll make sure.
And make sure in the order it says that the deposition is ordered to go forward on November 30th at 10 o'clock.
Yes, Your Honor.
All right, anything else, guys?
That's all I got.
I think that's it. Thank you, Judge.
You guys be safe.
Appreciate it. See you soon. Okay, Judge Hoffman.
Thank you.
All right, bye.
Bye.
Mr. Harder, what are you here for?
Hi, Judge. I am here for a temporary injunction hearing that Mr. Helstowski got started on that. He represents Munoz, I think.
You represent Munoz as well, or are you on the other
No,
side?
I represent Ken Bennett and Summit Residential and the Land Trust. I represent some of the defendants.
So is this going to actually go forward today?
Well, I'm here in case it does. I think we'll be prepared. I believe Jason Reed, who is with the, Riddle and Williams, is going to join us. So I think we'll be prepared to go forward. I don't know if Mr. Helstowski is or not. I assume he is.
Okay. How long do you think this will take?
It's his motion. I would imagine probably an hour at least. I'll have my client, Mr. Reed, will be available to testify on behalf of the homeowners association. And then, of course, I imagine Mr. Helstowski will have his client testify.
Have you all been to mediation yet?
We have not. We just got served on Friday. And in all honesty, I knew about the case. He had asked for a TRO a few weeks ago to enjoin us from moving title. And then he withdrew that. That was in front of Judge Purdy. And then he withdrew that. I told him, in front of Judge Purdy that we had no intention to do that and that we intended to file an eviction. And then he withdrew his application at that point to wait for my eviction case. And then once I filed the eviction case, then he amended to enjoin us from proceeding with the eviction.
So, Mr. Hart, I just wanted to tell you that although it's lovely, your Golden Gate Bridge, it's very old school,
Okay.
The background. You might want to come up with something else. Is that one of the standard ones that came with Zoom?
Yeah, I don't have the level of sophistication to come up with something more interesting, I guess. I had one on there before, but it was moving and I was told that it was distracting, so I got rid of it.
Yeah, they're very creative. It's amazing how far technology has gone in this area and how much things have changed. And it seems like I've been on Zoom my entire life at this point. So I kind of forget what it's like to have live hearings and things like that. So
yeah, I had one with Judge Lee, largely because I've got my son who's practicing with me right now. He passed the bar, I guess, a year and a half ago, and he was up in Oregon, and then he moved here. So he's applied for the Texas bar, and I wanted to get him a chance to get his feet wet down at the courthouse. So Judge Lee indulged us.
So is he doing live hearings now, I guess?
Well, I think if you ask for it, he does. So I don't think he's doing it as a matter of course, but I asked him and he was amenable.
All right, well, that's good. I'm only doing kind of contempt motions. If I have to put someone in jail, they obviously have to be here. But other than that, we're trying to avoid doing anything live.
Yeah.
We're going to try to do a remote jury trial tomorrow.
Well, that's going to be interesting to see how that works. So are all the members of the panel going to be at home on their own computers?
Entirely remote. The whole jury, all the attorneys, all the witnesses, everything is remote. We were going to do hybrid, but then the numbers got so high that we decided that was too dangerous. So I've been wanting to try to do a remote trial for a while. I've been studying this for quite a while. I don't know how it's going to go. There's a lot more work that goes into it than a normal trial, but I hope that once I've done it once, it'll be easier to do it again. And there are other judges that are beginning to look at the idea of doing a wholly remote trial. My current standard is that both sides, either it has to be a small car wreck case or something really small, and at least one side agrees, or if it's something bigger, if both sides agree. But I'm not intending to put major medical malpractice cases where either side objects to trial. It'll be for smaller car wrecks where at least one side really wants to go. And that's what I had 4 of those set for today, and only one of them is, or for tomorrow, only one of them is left.
So how are the jurors going to deliberate? By Zoom? Remotely?
By Zoom, yeah, they'll be in a breakout room. There's a lot of issues, as you could imagine, just on how you do this all remotely. But we're trying to work through each one of them. We'll see how it goes.
All right, it's going to be interesting because I can't imagine that the courthouse is going to open up until after the first of the year.
Oh, God, no. You just saw the Fauci said that the earliest we're going to be the last thing that jury trials will be the last thing that can kind of come back. And so if everything goes well, we're looking at maybe April, I think. And that's pretty optimistic. I'm hoping that we'll be able to do this hybrid format at some point, but right now it doesn't look likely.
It's got to be wreaking hell on everybody's dockets.
What'd you say? Oh my God, you don't even know.
It's got to be wreaking hell on you.
Oh, it's horrible. It's mostly small car wrecks. I mean, that's the thing is how are we going to, I have a fair number of bigger cases that are kind of being dragged along, but how do I deal with all of these small car wrecks that I'm resetting 10 a week that need to be reset for trial that I mean, I typically would try almost a case a week before, and now I haven't done that for since March. So what, 6 months, 7, how many months, 8 months now. I have honestly no idea how we're going to catch up. I'm hoping that once we get back to normal, maybe I can use a visiting judge or something like that to kind of catch up. But that was what I thought when it first started, is like, oh, we'll be out for 2 months and then I can get a visiting judge and we'll catch up. And I don't think that's going to happen.
In Collin County, they have like a car wreck-a-palooza or something like that, they call it.
What do they do?
Once or twice a year, I think, where they do nothing but car wrecks. And I would imagine if you're talking about the smaller type cases where, maybe accident and injury affidavits and that kind of stuff, they're probably trying 2 or 3 a week.
And how are they doing? Totally live?
Well, no, this is before. Yeah, this is before all the COVID stuff.
Okay.
Right.
Are they trying cases up there now? Like actual?
No. Matter of fact, one of my frustrations is I've got a case in Judge Roach's court. It's not even a trial. It's just a hearing to try to get rid of an intervention. And he was going to hear it live, and then he decided he didn't want anybody up there until January, and he doesn't want to do it remotely. So, I just stuck.
Remote is actually really pretty easy. I mean, it's really been remarkably efficient for hearings. I'm going to probably continue to do them for at least some hearings, even after this is all over, and maybe even bench trials if people want to. So I think remote is great.
I've grown to like it because I don't have to fight traffic to downtown and park and go through security and all that other kind of stuff. So the only area where it gets a little frustrating is if you have some exhibits that aren't pre-submitted to the other side of the court and trying to deal with documents and looking at exhibit 1, 2, 3, 4. Like even what we're going to do today, I'm assuming that there's going to be some exhibits. I don't know what they are. I don't know how they're going to get passed around and all that type of thing. So that's the one limitation, I think. But even there, I've had a few bench trials. I've had some temporary orders hearings and a bench trial in family law. I've had a couple bench trials in civil matters, and I've had a few temporary injunction matters. And I think as long as everybody's got their ducks in a row, it ends up working out okay. At worst, okay. And at best, it's a little better just because it's the convenience of the parties.
I agree. Mr. Kenbay, is that your name, Mr.
Oh, Ken Bennett, that'd be my client, I think.
Oh, okay. Is the other side going to show up, do we feel? Or I guess it's not quite for.
It's his party. I'm assuming so. If he doesn't, then.
Is Jason Reed on this case?
Well, he is gonna, I asked him to appear so he could testify. They're
He's
not,
one of your witnesses?
yeah, he's also, he's the HOA attorney and he's the one who was foreclosure counsel. So he's got the documents from the sale and, you know, the pre-sale and the post-sale and all of that. And I'm assuming that Mr. Helstowski will be here. If he's not, then I guess it'll make it easy for me.
Let's hope.
So I guess a couple of your colleagues are getting kicked upstairs or down on the second floor.
Yeah, no kidding. Yeah, it's kind of exciting but sad. Judge Goldstein is kind of my buddy here, and she's going to be gone soon. So I'm, a little sad. I'm happy for her, but sad for me because I think she'll be a great justice, but I'm gonna miss her here. So, and of course, Judge Smith I've known forever, and happy for him as well.
Well, I'm going to miss them both because I think they're both excellent judges. And even when they rule against me, I know they're going to give me a fair shake.
Yep.
And that's all you could ever ask for when you're doing, what I'm doing on this side of the bench. And then we'll have new people we'll have to try to figure out.
Yeah, the rumor is that Judge Lee will take one of their places at least. That's what kind of I've heard.
I would imagine he'll get one and maybe Judge Evans will end up being back down.
Yeah, I wonder if we're going to just, Evans keeps going back up and down and up and down. All right, so he's here, I guess.
A little bit of a yo-yo, yeah.
Yeah.
Well, of course, I remember back in the late 70s, early 80s when the courthouse flipped from D to R.
Yep.
And nothing is forever.
Now the Court of Appeals is flipping.
Yeah.
All right.
I see Mr. Helstowski is wearing his mask.
Hello.
Yeah, my client's here. Sorry, gentlemen.
All right, kind of tell me what's going on here, guys.
Hello, Your Honor. John Helstowski on behalf of plaintiff. I have Mr. Munoz is working right now, and so I have Emma, his wife, here today. We're seeking a injunction, Your Honor, in regards to a property, the subject property of this lawsuit. The property was sold for a $6,000 HOA lien approximately 120 days ago. Since that time, the parties sought to redeem it from a land trust. And during that process, they both tried to call, email, and find the individual, and they were unable to. There was one conversation that occurred, but they even drove by some properties and one of the businesses that they associated with that defendant, and they were unable to do that. And so they contacted my office. I believe it was 2 to 3 days. They thought they had 180 days. They were told they had 180 from the property manager. And they're a young couple. House is completely paid off, by the way. There's no underlying loan, or the condo is completely paid off. And so once they were unable to contact him, they reached out to my office, at which point in time I contacted Mr. Reed, who is representing the HOA, and said we'd like to try to redeem this. And I got some extra information about the purchaser, and we were unable to get a hold of them, though I did get the email from Mr. Harder at the time and told him about this situation. We filed the suit.
So you're going into a lot more detail than I was really meaning because we haven't gone on the record yet. I'm just trying to find out. So we've had a TRO in this case. Has it been extended?
No, Your Honor. This is the first setting.
That's what I thought. So is there a way this case could settle? Is there a possibility of that? Would it be what I typically do in this situation, if there's a chance it would settle, is that I have a right to and the ability to reset this for 2 weeks and give you guys an opportunity to try to work something out. But if that's kind of fruitless, then we can do the hearing.
We're absolutely happy to entertain settlement options, Your Honor, for the plaintiff in order to require it. Concerned, I don't know what Mr. Harder's client's disposition is.
Well, Your Honor, I haven't had a chance to discuss that one particular subject with Mr. Bennett. As I said, I've been aware of the lawsuit, but we only got served with this, I want to say Friday afternoon. Realistically, I don't know what the prospects are for settlement, Your Honor, but I never say no.
Is that the gentleman here, Ken B? Is that Mr. Bennett?
That's correct, yes.
Do you want me to put you into a breakout room so that you guys can chat about this?
Sure, that'd be great. Thank you, Judge.
And Mr. Reed, does he need to go too, or does he need to stay here?
He could probably stay with you, I guess.
Sorry, Mr. Reed. All right, so just the two of you guys. I'm going to give you how much time? About 3 minutes? Is that enough time?
That'd be fine.
Mr. Harder, Mr. Kent. Oops, sorry, Mr. All right, and then I'll bring you guys back.
Okay, we'll see you in a few minutes, Judge.
Mr. Canby, make sure you accept the invitation. Mr. Reed, how have you been?
I'm doing pretty well, Your Honor. Just trying to hang in there and not get sick.
Did you see the numbers today? 1,800 new cases. I mean, how does anyone avoid getting this?
I don't know. My wife and I are expecting our second little girl here in about 8 weeks, and
oh my!
So we're trying to be extra vigilant, and we haven't. We've been blessed so far. We haven't had any real issues. We're pretty smart about where we go and who we're around. But I don't know. I mean, everything I read, it sounds like it's just getting, it's getting out of control where you can't even, nobody can tell who they're getting it from or where they're getting it. I don't know.
My son got it this summer. He, he's at UT with my daughter and son are both at UT, and he went down to UT. After spring break, he came up here and kind of got stir crazy and really wanted to go back down to Austin. And so we finally let him in June, and he almost immediately got COVID from one of his mock trial partners. And the whole team got it. And some of it was pretty serious. His was very minor, but some of it, this thing is no joke. I mean, I don't know politics, but some people, it's no big deal, but even people who don't go to the hospital, one of his friends who got it, one of his mock trial friends, she still has symptoms and she got it in June. I mean, it's not.
Yeah. My wife's sisters got together over, I guess it would have been, maybe it was Father's Day. Mm-hmm. Anyway, didn't invite us, but then but unbeknownst to them, my brother-in-law, who's a Dallas police officer, he had contracted COVID from his, the guy that he shares his office with. And so by the time they all kind of found out, they all had it because they were all together that weekend. And one of my wife's sisters, she says she still has lingering problems from having it. I have another cousin who swears that she's still kind of suffering, side effects from having it, for like respiratory issues. So yeah,
it's rough. It's very rough. I hope we can get There's another vaccine that just got announced today. I'm hoping that maybe the light is at the end of the tunnel, maybe not super soon, but at some point. So
yeah, well, we wear, I mean, the partners here at our firm, we all wear masks in the office if we're out in the common areas of the office. Just, you know, and we all have to check our temperatures when we come in every morning. I mean, whatever we can do to stay safe.
We actually had somebody feel ill. And so, of course, we sent them home, and we practiced the same thing, I think, as Mr. Reed had said. And you know, I got a test for her, and she got a negative test. And so this is on a Thursday. So on Friday, she got the test, and then ultimately came back on Monday. She didn't feel bad at all. Well, on Monday afternoon, she gets a call. They had done 2 tests, and she gets a call back, and the second test was positive, and she had come back up. So I had to, it was the right thing to do. It was the only thing you can do. The entire office had to get tested and then work from home. They were telling, this is approximately 3 weeks ago, they were telling me 10 days if you had a test. And so she ended up having 4 tests, and the one was positive. And then one other staff member had 4 tests, 2 of the blood ones, and then 2 of the breathing ones, the ones with the swab. And she also got 1 positive and 3 negatives. And so
I just don't get that, how you have 1 positive and 3 negatives. That's just strange.
Well, I guess the antibody test doesn't pick up the antibody ones. When I say 2 of those, they're administered at the same time. One's designed to check and see if you have antibodies as early as 72 hours after contracting it for 7 days after that. The other is from day 11 on. So the problem with that test is it says if you've had it, but not if you have it. And so then on the instant one, it has a more likely of an error rate. And the one that is sent away takes 72 hours from when they do it. That is also the area where they draw it, you know, it's one of your nasal cavity, however you say that. That's as if your body's excreting it, and that's a higher accuracy rate. So I guess it was the best $1,000 I ever spent, though, for everybody to get it. Seriously, right? And thank goodness that we were, you know, she's a young lady, and she's been working with me for a little while, a couple of years, and so she can do 70% from home, and it is what it is.
Yeah, right? I hope she's okay. So, Mr.
Everybody's good. Thank
you. Yeah, Judge. So we'll be open to see if there's something we could do to resolve the case and agree to extend the TRO for a couple of weeks and reset this. And if we can figure a path forward, great. And if not, then we'll come back.
So who do you want to use as a mediator?
Well, we could use King Pfeiffer or Ken Rubenstein or John Shipp. Any of those 3 are fine with me. I don't know how John feels.
I'm fine. Pfeiffer or maybe Jay Zaleski. King Pfeiffer is a good guy. I haven't used the other folks. If you got somebody you like, Ken, that I should know, let me know.
Well, John Shipp
is real good in these kinds of
cases.
No.
You don't like
let's do that then.
No, but Pfeiffer is good too. I don't.
Oh yeah.
All of those are great mediators.
Yeah.
Let's use Ken Rubenstein just because it sounds like I need to.
Yeah, I just can't. He's been around so long. I can't believe anybody's not used to him. I used to mediate with them for years, but when I was in private practice, and he's still very popular. But Ken, I mean, Mr. Harder, who do you think would be best for this case? I think all 3 of those are good mediators.
Any of those 3 would be fine. I think it's just a matter of who we can get in on the short notice, and I think a half a day ought to be adequate.
I agree, and then it'd be nice if we could do it via Zoom, right?
I think they're all. I know John Shipp is doing Zoom. I've got a Zoom with him coming up this week or next week.
I have one with King Pfeiffer next week, and I know he was doing it via Zoom, and he fixed some technical problems he was having. That's why I brought up Jay, just because I know he's doing it as well. So
I'll tell you, I like Jay personally, but I've never had much luck with him in these kinds of cases.
okay, well, let's do somebody different then. How about either Pfeiffer
Let me do
or-
this. Let me try to
Yeah.
call Burden Mediation, see if I can get one of them on the phone, because Pfeiffer's still with Burden, right?
Yeah,
Yes,
as far as
he
I
is.
know.
I'll call him right now. Well, and let me ask you this. Is this Bert? Hello? That was weird.
They were having phone problems sometime mid to late last week. I have the email for the woman who seems Cindy or something.
Okay, that's weird. Okay. Yeah, they just hung up on me. That's strange. Well, so let me kind of just raise one issue with you guys, and I'm flexible on this. Next week is Thanksgiving. Are you going to have time to be able to get a mediation in, or do you want to? I can't order you to go more than 2 weeks, but do y'all want to agree to like reset this in a month, or what is y'all's preference?
I'm fine with letting Ken pick the time and the place, so long, and the mediator, anybody we just mentioned, so long as it's the mediation isn't next week. And then Ken, I think it'd be assumed that we try our best, and if not, I'd have to re-up for the injunction hearing, and resetting it's on me.
So I'm looking at my calendar.
Yes,
And I
sir.
think next week would be tough. It's a short week and I'm getting out of town on Wednesday on pain of being divorced. So I could probably mediate.
Anytime
this
after
thing.
December 2nd for me, because December 1st is foreclosure Tuesday. I'm usually just the 30th and the 1st are going to be, I bet we're all busy.
Well, stop foreclosing people. Yeah, I could do the 3rd or the 4th if we can get in with one of the mediators. And then maybe we could set this for sometime the following week, in case.
Yes, sir.
So what day are you talking about? December. Wow, December. That's amazing. 7th? Is that what you're thinking?
Yeah, any day that week works for me, Judge. And I don't mind maybe doing
injunction
the,
hearings on December. Do them at
you do on Monday?
Mondays.
Okay, well,
That
then
sounds good to me.
maybe the 7th, and then John and I have to just hustle our bustles and get in with somebody for half a day before then.
All right, so go ahead and send me, you guys will have to prepare the order because that's beyond my 2 weeks. So you'll need to do an agreed order, extending it for 21 days and, or extending it to December, and we'll do it at 4 o'clock again.
Okay. Yes, sir, Your Honor.
Anything else, guys?
Not for me, other than to say
talk
happy
to anybody you don't
Thanksgiving to
know.
you, Judge.
You guys be safe out there. Mr. Reed, good seeing you as well.
Good to see you too,
And
Your
just,
Honor.
but make sure you email me an order, preferably by tomorrow, on this.
I'll circulate one right now to all parties, and then get it on as soon as I can. Thank you very
Fantastic.
much.
All right, you guys be safe, okay?
Okay,
Yes,
thank you, Judge. Bye now.
All right,
You too.
bye-bye. Okay, Tony, I just want to remind you, we're starting up at 7:45 tomorrow morning.
Okay, 7:45.
And Rhonda, did you do the email that we talked about or not? Rhonda, you there? Can you go see if you can get Rhonda? Oh, she hasn't done it yet. Okay. Oh, did you send it to me? Oh, I haven't seen it. Okay. When did you send it?
I think it was before we started, around after 1:30.
I don't see it.
I'm trying to think what would be.
Notice of username, but that's what the juror.
Maybe it was before that, because it was when Nick them was in my office, so they had to be around 11:30 or 12 or so.
Okay. And this is a proposed email?
Well, it was an email, and it was just saying, virtual updates. What our name is, virtual.
Okay, Andrea, we'll see you tomorrow or whenever. And if not, I'll go ahead and text too about where we might want to meet for lunch on Friday. We'll just meet for lunch directly on Friday.
Sounds great. Can't wait to see y'all on Friday.
All right, thank you. Bye-bye.
Bye.
Is that it for me, Judge?
We'll see you
Tomorrow?
early tomorrow. We got to be